Hello, I'm Joanne Sefton and I'm an employment law barrister at Mitchell Law. I'd like to welcome you to the Mitchell Law Tea Break. This is an occasional series of short videos for HR professionals, and today we're going to be talking about annual leave and holiday pay. And to do that, I'm joined by Mitchell Law's Director, Catherine Mitchell.
Hello. Holiday pay. I suppose we might as well start with the recent European Court decision of King and Sash Windows.
He did all right for himself, Mr. King, didn't he?
Well, the European Court agreed that he's entitled to 13 years worth of unpaid holiday pay worth about $27,000. That should get him a bit more than a weekend Skegness.
I think you could get a very nice holiday for £27,000. That, of course, is one of the critical parts of the decision, but how far back, how many years holiday pay he could claim. But for me, the other critical part of it was that fundamentally it's a claim about employment status. Mr. King thought he was self-employed, the business thought he was self-employed, that's why he wasn't being paid holiday pay. But when you actually look at the definition of worker, which is the key to holiday pay entitlement.
You don't need to be an employee, do you? Just a worker.
You can be a worker, and when you look at that definition, it's very wide. Essentially, if you're performing the work yourself, if you're doing the work personally, and you're not doing it in the course of some genuine substantive business of your own, then there's a very good chance that you'll be able to show that you're a worker.
I think that's right, and for a number of years it was thought that you're probably safe and you could get around that if your so-called self-employment contract was drafted tightly enough. But what we're seeing is the types of cases like the Uber and Pimlico plumbers, it's not that easy at all, and that rapidly increasing awareness and willingness to challenge employment status from the unions and the individuals themselves means that anyone out there who does use these supposedly self-employed contractors and doesn't offer them workers' rights like sick pay and holiday pay might need to be taking a long hard look at that. Yeah,
I think that's a very good plan. It's interesting that you mentioned the Uber and Pimlico cases. Of course, they're both still ongoing at the moment. The workers seem to be succeeding in showing that they're workers. But coming back to the case of King, I think what it does is raise the stakes in some of those ongoing employment status cases. Because if you suddenly prove that you are a worker and you can then claim back pay for unpaid holiday without any backstop, it makes those claims much more valuable.
Very valuable indeed in some cases, if we're talking about going back to 1996 when the working time regulations came in.
They did.
Although I don't think there were that many Uber drivers around then.
Maybe not.
But I think it's also, we're thinking about a big impact for people who weren't paid holiday pay at all. Also those people who are claiming holiday pay top-ups to take account of things like overtime and commission. Do you remember not so long ago the whole flurry of cases like Lock and British Gas, Barefalton and Scotland and those?
Yeah, that's right. There was a real concern at the time those were being brought about how far back these claims were going to be allowed to go.
And I think at that time the Employment Appeal Tribunal effectively made a policy ruling in the Barefalton case so that claims couldn't go past the 3-month gap. So if you had a 3-month gap between underpayments and you had the 3-month break and no holiday had been taken, you were okay. But it's hard to see how that can sit alongside this King decision. And when you look at the European Court judgment, it's very clear that the employee is entitled to be fully compensated for any holiday they didn't take or weren't paid for. End of story.
Yeah, that definitely seems to be what the European Court's saying. Of course, the other thing that probably made holiday pay claims drop off a little bit was the introduction of tribunal fees about the same time. Because you might well think twice about bringing a holiday pay claim if you're looking to claim 2 or 3 years worth of holiday pay and you've got to pay that fee. Now the fees have been abolished, what have you got to lose?
Not very much, I don't think. And I think that means we could predict there could well be an awful lot of holiday pay claims based both on the worker status arguments as well as those top-up arguments for the next couple of years. And from any business point of view, it's worth auditing any risk areas.
Well, I expect a lot of businesses are doing that. But not every business has self-employed contractors or even people on commission and overtime. And I think it's worth mentioning we get a lot of other holiday pay queries that have nothing to do with those areas.
Absolutely. I think employees going sick on holiday for a start, and I've written sick pay policies for several employers where they felt employees were potentially pulling a fast one by claiming to be sick on holiday and then looking to take holiday time again at a later date. Maybe they've been listening to some of those lawyers' adverts about suing for food poisoning on holiday.
Maybe they have.
And I've had quite a few interesting cases about how to calculate holiday for term time workers and whether they need to work extra days if a bank holiday falls within term time.
It's a complicated area because there's not very many court or tribunal decisions that deal with term time working. Ideally, you need to make sure that you've got a really clearly worded term time only contract so that both the employer and the employee knows where they stand on it. I think we'll see more and more institutions are already moving towards using term time working, so we'll see that applying to greater numbers of people, and I guess we will see those cases start to come into the courts.
I think you're right. So speaking of holidays, anything interesting planned for you this year?
I think we're off to France in the summer. I've not got anything else organised. Didn't you have a query recently from someone about whether they could discipline a senior executive who'd been refusing to check his emails while he was away on holiday?
I did have something very similar to that, but don't worry, we've got your emails covered when you're in France.
Excellent. I think I might be out of signal anyway. That's it for this episode of the Mitchell Law Tea Break. We hope that you've enjoyed it, and if you've got any issues over annual leave or holiday pay that you'd like to chat to us about, then do give us a call. Thank you.